Hello, my name is Michael Tesoro, and I've prepared this ACCC video note entitled Up, Up and Away, Proposed Increases in Competition and Consumer Law Penalties. Now, a bit of background about myself. I'm a competition and consumer lawyer, and I've been working in my own practice, Tesoro Legal Consulting, for the last 14 years, and I help companies with competition and consumer law matters. Prior to that, I worked in the ACCC for 15 years in a variety of roles, including as a Director of Enforcement. Bit of an outline to the presentation. I'll start with some background, then discuss the proposed increases to the penalties, then discuss the rationale for the changes, then outline what I see as some unintended consequences of the changes, and then finish with some commentary. Now, the proposed increases were brought in response to a election commitment to increase the penalties, and the Albanese government had indicated that it wanted to increase the penalties, although it wasn't entirely clear as to whether they were proposing to increase both competition and consumer law penalties. But Dr. Andrew Lee, who's the Minister in charge of competition policy, issued a press release where he clarified that it was both competition and consumer law penalties that were going to increase. And some draft legislation was released. And only a very short period of time was given for people to respond to that draft legislation, which suggests that the current government is in a bit of a hurry to bring this new law in. So the current laws governing penalties under the legislation are 76 under the Competition and Consumer Act and Section 224 of the Australian Consumer Law. And the way it works is the courts are required to impose a penalty which is the greatest of three measures. The first measure is $10 million. The second is 3 times the total value of the benefits attributable to the illegal conduct, or 10% of the annual turnover. So the way that works is effectively if a company has a turnover of under $100 million, it's likely that the court will start with the $10 million threshold to determine the penalty. But if the company has a penalty over $100 million, then they'll look at either the 3 times the total value derived from the legal conduct or 10% of annual turnover. Now, in practice, it has been impossible to calculate the 3 times the total value generated from the illegal conduct with any certainty. So the courts have effectively defaulted to the third measure, namely the 10% of annual turnover. Now, there are 3 main proposed changes to that law. The first is to increase the initial threshold from $10 million to $50 million. The second is to increase the percentage turnover threshold from 10% to 30%. And the third change is to introduce this concept of breach turnover period. So the way this legislation is going to work is that companies that are smaller are going to be subject to an initial penalty of $50 million as the maximum penalty for the breach, and sort of the cutoff for that will be about 170 million. And the reason for that is that 30% of 170 million is marginally over $50 million. So what will happen is companies with a turnover of less than $170 million will be looking at the $50 million penalty as a starting point, and companies over that 170 million are likely to be subject to the 30% of turnover. Now, a very big change that's being introduced is this breach turnover period. Currently, the way the law works is that the penalty under the 10% threshold is calculated on the basis of an annual turnover amount. So effectively 12 months of turnover. But under this new provision, the way it's going to work is that the company will effectively be fined for the whole period that they were engaging in the contravention. So when they're working out the breach turnover, they'll look at when the illegal conduct began and when it ended, and add all the annual turnovers for the company over that period together, and then multiply that by 30%. So if there was a company that had engaged in 3 years worth of contraventions, the annual turnover for those 3 years would be added together, and that would be times 30%. So this is going to be a significant factor for either very large companies with very large turnovers who engage in conduct in breach of the legislation for a number of years. I think the example that stands out the most is a long-term cartel that might last for 10 years that is uncovered. In that circumstance, it's the legislation would mean that it's 10 years worth of turnover that will be added together, and then the 30% threshold applied. So as you can see, the penalties are going to go up very significantly as a result of the introduction of the breach turnover threshold. Now, individual penalties are also proposed to go up from $500,000 to $2.5 million, which is a very large increase. Now, in the explanatory memorandum explaining why these changes are being brought in, the government identifies a few arguments. And the first is that for the last 30 years, the maximum penalty in breach of competition provisions has not increased above $10 million. And that, on one view, is correct. The threshold amount for a breach of the competition provisions remains at $10 million. But there has been a very significant change within that time, which is to introduce the 10% of turnover penalty amount, which has had the consequence of increasing penalties significantly. So I think saying that there hasn't really been an increase in competition penalties for 30 years is not really entirely accurate. It's also reference to this 2018 OECD report, which found that pecuniary penalties in Australia were very low compared to other international jurisdictions, and that report seems a bit dated now. There's been a lot happening in the last 5 years, and penalties have risen quite significantly in that time. A lot of the cases that were being looked at in that OECD report referred to the earlier penalty regime. So I think to try and rely on that report in 2022 is not a very sound argument. There's also reference to the need to have Australian penalties comparable with international jurisdictions, and I guess when you're looking at Europe, there's enormously big penalties being imposed of many billions of euros, and the penalties in Australia are much smaller, even on a relative basis, given the smaller turnovers of Australian companies. So there's clearly a desire that our penalties are going to come more in line with the big penalties being charged in competition law cases, both in the European area and the USA. However, I think in terms of consumer law penalties, there is not the same argument in favour of the increase, because it's pretty apparent that the consumer law penalties being imposed in Australia are the biggest in the world. So there's no need to catch up to the rest of the world in relation to consumer penalties. The explanatory memorandum also mentions the need for maximum penalties in consumer cases to ensure that deterrence is achieved, and that's clearly the purpose of civil pecuniary penalties as set out by the High Court in the recent Pattinson judgment earlier in the year. And then finally, there's an observation that it's important to align the consumer penalties and the competition law penalties. And I think that's a valid argument, because the impact on consumers of both competition and consumer law breaches are quite similar. They have devastating consequences for consumers. So there's a strong argument that the penalties should be aligned. Now, there is an unintended consequence arising, I think, from the legislation with the introduction of the $50 million threshold penalty. And I think it's well demonstrated by this case that the ACCC took against Superphone back in 2021. Superphone was a very small telecommunications company which breached the law in its telemarketing activities. And what Superphone did, it admitted all its contraventions but sought to challenge the penalty amount being sought by the ACCC. And as you can see, it's a small company with $1 million turnover, a net profit of only $5,000, and it generated benefits from its illegal conduct of $20,000. So what it argued to the court in the case was that using the $10 million starting point would be inappropriate, as it would result in a disproportionately large penalty, which was likely to force Superphone into liquidation. And Superphone encouraged the court to look at the other two measures under the legislation, namely the 10% of turnover measure, which would have resulted in a maximum fine of $100,000, or the 3 times the benefit measure, which would have resulted in a maximum fine of $60,000. So it argued that those level of penalties were more appropriate given the conduct that Superphone engaged in, as well as its financial standing. However, the ACCC argued strongly against those submissions, stating that the $10 million measure was where the court had to start. Now, Justice Murphy was the judge in this case, and he agreed with the ACCC that the legislation didn't really give him an option to try to use one of the other two measures. It was clear that the legislation said that he had to use the greater of the three amounts. So he was locked into using the $10 million penalty as a starting point. He also got some comfort from the explanatory memorandum, which set out the Parliament's intention when they increased the penalties, and it's all directed at seeking to introduce higher maximum penalties to achieve deterrence and compliance, and to prevent companies seeing breaches of the law as being a cost of doing business. So ultimately, he didn't agree with Superphone's submissions, and he imposed a penalty of $300,000. And that penalty reflected 30% of Superphone's annual turnover. In terms of its profitability, it was approximately 60 times its net profits and 15 times the benefit which it derived from the legal conduct. So as you can see, the legislation worked to impose a very big fine relative to the size of Superphone's operation, its profitability, and the benefits it had gained from breaching the law. And I think and the further thing that occurred was Superphone was unable to pay the penalty and did go into liquidation. So what this throws up is the unintended consequence of introducing a $50 million penalty as a threshold amount, because this $50 million will apply to every small business which is taken to court by the ACCC. And the problems which were identified in Superphone will be magnified by five-fold, because it's an increase of 5 times in terms of the penalty. So I think this is not what the Parliament intended. They didn't intend to have very severe penalties imposed on small business, but I think it's going to be very difficult for courts to whittle down a penalty which starts at 50 million down to a number that is going to be able to be paid by a small business. It's simply not going to be possible to reduce that to a number that a small business would be able to afford as part of their current operations. So the consequence of the increase of the initial threshold is that small businesses who get sued by the ACCC are likely to simply go into liquidation, because they'll see that there's no way that they'll be able to pay the penalty that is going to be imposed at the end of the litigation. Now, one thing I'll just sort of demonstrate here is how this breach turnover period works using this Samsung waterproof case, which was decided by the federal court earlier this year. And as you can see, the conduct occurred from March 2016 to October 2018. So that's roughly 2 financial years. And in the judgment, there was details of Samsung Australia's annual revenue. So as you can see, in 2016, its annual revenue was 2.3 billion. In 2017, it was 2.4 billion. So over the breach turnover period, had this current law been in place, the total starting point would have been $4.8 billion, to which you'd apply the 30% threshold, which would have resulted in a maximum penalty of $1.4 billion. So as you can imagine, even with all the factors, all the penalty factors going in Samsung's favour, it's not going to succeed in reducing that penalty down to 20 or 30 million. Rather, there's a clear expectation that even if all the factors go in the respondent's favour, the penalty will still end up in the hundreds of millions of dollars. So I think we can expect very large increases in penalties as a result of the changes, particularly the use of the breach turnover period and the application of the 30% turnover threshold. Now, just some final commentary. Are the changes needed? In my view, they're not really needed. I think the penalties have been edging up quite nicely over the last 5 years. The courts have definitely got the message that the penalties need to be increased. They're giving effect to parliamentary intent that penalties need to be raised, and that has been happening constantly over the last few years. In some respects, the courts have shown a bit better insight into this issue than the ACCC. For example, in the Volkswagen case, the ACCC came to the court with an agreed penalty of $75 million, which was rejected by Justice Foster, who then imposed a fine of $125 million, which was affirmed by the full federal court. So that shows that the courts are understanding the purpose of the legislation and the need for larger penalties to achieve deterrence. So I don't think these changes are required. the law was heading in the right direction and the penalties were, I think, in a few years' time going to end up at very high levels. Furthermore, are the changes likely to damage small business? And I don't think there's any doubt that they will. I think any little small business who gets taken to court by the ACCC is going to be facing a starting point of $50 million, and that's simply going to be a penalty that, even if it's whittled down significantly, is still going to end up at a number that is much too high for them to pay. So a lot of small businesses are going to be forced in liquidation in the face of ACCC litigation. Furthermore, the individual penalties at 2.5 million is going to have a significant impact on small business owners and operators, and likely to result in a number of them who are sued by the ACCC going into bankruptcy. So these issues, I don't think, have been thought through and need to be looked at by the government. Now, I think there is an alternative approach available. The simplest thing would be not to increase the initial threshold penalty above $10 million and leave it as it is, but you'd still have the superphone type problem. So what I think would actually make more sense is to reduce the initial penalty to a lower amount. Now, I know that sounds a bit counterintuitive, but when you think it through, it does make sense. For example, if the minimum penalty or the maximum penalty was reduced to $1 million, what that would mean would be that any company that was generating less than $3.5 million in turnover would be subject to the $1 million penalty maximum. So that number would be reduced a bit through various considerations, and a penalty arrived at which many small businesses may be able to pay over a period of time. Once the turnover of the company hit 3.5 billion, the 30% threshold would apply, and that would increase slowly as the company had a greater level of revenue. So it seems a much better approach to achieve penalties which are proportionate to the size of the business, to actually reduce the initial threshold amount from 10 million down to 1 million and have a much more graded increase in terms of penalties. Now, I don't know if that's something that's on the table with the government, but it's something that should really be considered to avoid the unintended consequences which these changes are going to have on small business. So that's all I had. I think it's interesting, this legislation and its unintended effect on small business, and it is important that the government get the balance right, and the only way that I see that they can get it right is to either reverse the decision to increase the initial penalty from 50 million back to 10 million, or even preferably to reduce it further to say $1 million, and then do the calculations, and you'll see that the impact of that particular penalty regime will be much more equitable than what is being proposed. So if you have any questions about this particular presentation, feel free to give me a call or send me an email. Bye-bye.